This is Jennifer Lim. I'm the chair of the section. I'm delighted. We're very fortunate to have Kekoa Keiley.
Yes.
And Kekoa, board members remember that Pam raised him or brought him to our attention in January and said, we've got this terrific guy working at our firm, and he can talk about this really arcane subject that we should all probably know about, because we might have clients who are going to get themselves in trouble if they're not aware of that, and that's these BE 13 surveys, which is foreign direct investment into the United States. So that's what Kekoa is going to talk about. Again, the materials are hyperlinked on the website. He was kind enough to bring lots of hard copies over by the door if you're interested. I'll give you a 30-second intro on Kekoa, and then I'm going to turn it over to him. So as I mentioned, Kekoa is an associate over at Pam's firm at Chung Kerr. He graduated from UH in 2011. Between the time of graduation and starting with Chung Kerr, you were a clerk for Judge Nakamura.
Correct.
I see.
Yes.
You also were summer associate, was it, with Native Hawaiian Legal Corp?
Yeah, that was in law school. Correct.
Yeah. He was very busy in law school. In addition to racking up at least a half a dozen spectacular student kind of awards, was a research assistant with David Calley's, property tutor, various other academic, good, interesting things that he did. And I just learned 5 minutes ago that you were the assistant restaurant manager at Hotel Hana before you went to law school. So this guy's kind of the full package. He can talk business and he can talk academics. So with that, thank you very much for being here.
Thank you, Jennifer.
And we'll turn it over to you. So let's give you a
thank you. Thanks. Well, as Jennifer said, my name is Kekoa Keiley. I'm with the law firm of Chung Kerr. I've been there for the past 2 years. And today I'll be talking about foreign direct investment into the United States and the reporting requirements under the BE 13 survey. This survey actually went out of, they weren't collecting the survey since 2009, but recently in November they started collecting the survey again and actually made it retroactive for any transactions that occurred from January 1st, 2014. So as of November 14th or 24th, 2014, if during any period in 2014 you had a client who was a foreign company who acquired an interest in a company in the United States or started a company in the United States, they were actually subject to this reporting requirement. And there's obviously other conditions to the reporting, but which we'll discuss in a little more detail throughout this conversation. Basically, there's 6 different forms that are part of the survey depending on what type of transaction has occurred. There's BE 13A, B, C, D, and E, and then there's an exemption form. If you take a look at the materials, I've included all of the forms as well as a cheat sheet to each of the forms telling you when you need to file it, when each one applies, and then also giving certain examples of what you should and should not include on those forms. Primarily today we're just going to discuss a broad overview of the forms, when to use each form, but we're not going to go into too much detail as to how you fill out each of the items on the form, because they're actually not that difficult to fill out. These are introductory surveys which allow the BEA, which is the Bureau of Economic Analysis, basically to figure out whether or not they need you to continue filing forms on either quarterly, annual, or 5-year basis. So based on the information you disclose in the survey, they'll contact you and say, okay, now you need to start filing quarterly or yearly or every 5 years. Okay, so who has to file the BE 13? Basically, it's any company who has a direct investment by a foreign company. So it's a U.S. entity or U.S. business enterprise which actually has to file. It's not the foreign entity or person who acquires the interest. And it has to be a 10% voting interest in the company. So anything under 10%, there's no reporting requirement. And for purposes of a U.S. business entity, it's important to note that the purchase of real estate is considered, or the holding of real estate is considered a U.S. business enterprise. So if your client is a corporation in China, they want to develop property, they purchase a piece of property in Hawaii solely, they have 100% of the interest in the property, they're subject to reporting. So how do you, or when do you file? It's basically 45 days from the date of the transaction. So if you purchase, you have to file within 45 days. If you establish a new company, 45 days after you establish the company. And how do you file? I've listed just the links and the phone numbers and the mailing addresses here that you can use to either electronically file or fax your application or your reports in, or mail it in. And the forms can be found at the link at the top there. And it's important to file. Why? Because you could be subject to fines up to $32,000 for every violation. And if it's a willful failure, your client could go to jail. But I doubt that'll happen to anyone. Basically, the most important things to know about filing these forms is the terms. Once you understand the terms, you're able to fill out the form fairly easily. So we'll just go over a few of them right now. Foreign parent is the first entity outside of the United States which holds a 10% interest or more in a U.S. company. And then the ultimate beneficial owner is the foreign entity when you go up the chain of ownership from the foreign parent, who is not more than 50% owned by another person or entity. And a U.S. affiliate is a U.S. business enterprise who is that's directly or indirectly owned by a foreign entity holding at least 10% of the U.S. business enterprise's voting interest. So basically, if a foreign company holds 10% more or more of a U.S. company or entity's voting interest, then you are a U.S. affiliate. If a foreign company holds not 8 or 9%, then you're not considered a U.S. affiliate, and none of this applies to you. So I set forth a couple of examples just so I know a lot of this for people who haven't seen the forms can be, you haven't applied it, so it's hard to understand. So I just put a couple of examples that we can go over to basically identify who would be a foreign parent, who would be the ultimate beneficial owner, and who's the U.S. affiliate in each of the examples. So for example 1, company 1 and 2 and individual A own company 3 50%, 25%, and 25%. And company 3 owns company A 50%, and company 4 owns company 5 10%. In that example, the foreign parent would be company 3 because it's the first company outside of the U.S. which holds 10% or more of company 4. The ultimate beneficial owner would be company 3 because none of the entities above company 3 hold more than a 50% ownership in company 3. So even though company 1 holds 50% of the interest, that doesn't count. They actually have to have a controlling interest of the foreign parent in order for it to go up to being an ultimate beneficial owner. And then the U.S. affiliate would be company 4 only, because company 5 only has, if you calculate the voting interest in company 5, which is held by company 3, it's only 25% because company 3 owns 50% of company 4, and then company 4 owns 10% of company 5. Oh, I'm sorry, it's 5%. it's 10% of 50%, which is 5%. So because company 5 is not, the voting interest in company 5 is not held more than 10% by company 3, it's not a US affiliate and would not be subject to any reporting requirements. Okay?
But if company 5 were 100% owned by company 4, then they would both be, and you have to
Right,
file 2 forms?
correct,
Okay.
yes, yeah. And then, of course, that would be based on what sort of transaction occurred. It's not by not just solely because it's held, it has to be like an acquisition, an establishment of a new company. So if company 5 or company 4 was 100% owned, and then company 4 established company 5, that would trigger the reporting,
Okay.
right?
Thank you.
And then again, in example 2, you see the numbers and the ownership interest. The foreign parent, again, would be company 3 for the same reason. But in this example, individual A would be the ultimate beneficial owner because it holds majority interest in company 3. I know that a lot of our foreign investor clients have some concern about confidentiality, and so they don't want their individual names on forms that they don't necessarily know exactly where they're being filed. But the good thing is that the form actually only requires you to put individual, like the word individual, rather than disclosing their actual name. And then, again, in this second example, the US affiliate would be company 4 only, because 5% of 100% is only 5%, so company 5 doesn't have that 10% threshold. Okay. This is gonna take a long time. Okay, affiliated foreign group. So the reason why an affiliated foreign group is important is because for purposes of the 10% voting interest, you actually have to aggregate all of the interest held by the foreign group. So if 2 foreign entities each hold 5% in a US entity, the aggregate would be 10%, and the US affiliate would be subject to reporting requirements. So basically what you do is you go up the chain to determine who is part of the foreign group. You have to go up the chain of the foreign parent and determine who has a controlling interest, and then also go down the ownership chain of all of those groups and determine who is controlling ultimately. And so in the example 3 that I provide, foreign company 1 to foreign parent and the foreign subsidiary, basically all of those companies are part of the foreign group, or the affiliated foreign group. Whereas in example 4, only foreign parent, foreign company 2, foreign company 4, and foreign company 5. So basically everybody on the right-hand side of the example, no one on the left-hand side, because the 5% interest basically cuts off foreign company 1 from the foreign group because it's not equal to or greater than 50%. Sorry, I know a lot of this is so confusing because you haven't seen the forms and applied it, but if you have questions, please feel free to stop me. Okay, finally, voting interest. So clearly voting interest is important because that's determining when you have to file. The voting interest is not necessarily your ownership, your straight ownership, equity ownership in the company. It actually has to be a voting interest. So for corporations, capital stock, your percentage of capital stock, that would be your voting interest, provided that you haven't limited somehow in your articles that you don't have any voting rights connected with the capital stock. For example, if you had preferred stock with no voting rights, those would absolutely not count towards your voting interest. So if a foreign company wanted to invest in a US entity and they only purchase preferred stock, they can get their distributions, but they don't have any voting rights, they wouldn't, the corporation would not be subject to the reporting requirements. Similarly, with general partners, we would assume that all of the general partners have an equal voting interest because they all govern the operations of the partnership. In limited partnerships, limited partners would not be considered as having a voting interest in the company unless, of course, somehow you deviate from that general rule in your partnership agreement. The general partners, of course, would have an equal share. And then in limited liability companies, it gets a little strange. In member managed, you of course would have equal interest allocated among all of the members unless otherwise deviated in the operating agreement. A manager managed limited liability company where the manager is also a member, you have to look at what control is relinquished to the managing member. If the members still retain some sort of power to approve budgets or to approve any other large management decisions, then the BEA would consider that to still have, those members to still have a voting interest. So that takes a little bit of a deeper analysis. All right, so now we're actually going to move on to the specific forms that have to be filed. As I mentioned earlier, there's 6 forms, the BE 13A, B, C, D, E, and the exemption form. The BE 13A is basically whenever there's an acquisition. That's the triggering event, is when a foreign entity purchases or acquires a 10% or more voting interest in a U.S. entity, either directly or indirectly, by purchasing like a subsidiary of an existing affiliate. So this would include the purchase of U.S. real estate, as I had mentioned earlier, but it's only the real estate which you intend to lease or sell without first adding significant construction. So if you buy a property for purposes of constructing a condominium building, that would not be covered by the BE 13A, but it would be covered by the BE 13B, which we'll discuss after this. You would exclude the acquisition of voting interest in a U.S. affiliate that's already controlled 10% by a foreign company, and you would just report that on the claim for exemption. Oh, and then also you exclude real estate transactions which are solely for personal residential use, even if it's acquired by a corporation. But so a lot of people to block liability, they'll buy their residence in an LLC. That use, as long as it's used for the member's personal residence, then it wouldn't be subject to reporting requirements. Okay. And so I've got a couple of examples at the bottom of the page, which basically evidence direct and indirect acquisition by a foreign parent. So in the first example, the foreign parent acquires a U.S. affiliate 15% interest, and that U.S. affiliate already had a subsidiary. Because if you see, I put on the side a note, it says, you have to consolidate the reporting here. Whenever there's a U.S. affiliate subject to reporting who owns a subsidiary 51% or more, or greater than 50%, I guess you could say, then they have to file fully consolidated reports. Even though in this case, if technically the subsidiary of the U.S. affiliate isn't necessarily a U.S. affiliate, because the voting interest which the foreign parent holds in the subsidiary is actually less than 10%. But because it's a consolidated basis, then it would actually be folded into the report for the acquired U.S. affiliate. Okay. And the next example was just where the foreign parent is not actually acquiring the property or the company. It's actually their U.S. affiliate buys a subsidiary, and they would still be subject to the reporting, even though it's a U.S. company acquiring a U.S. company, because ultimately the foreign company still has over a 10% interest in the subsidiary which was recently acquired. And that's just by multiplying out the percentages.
In that example, the existing U.S. affiliate, if they hadn't acquired, I mean, if you just took away the bottom one, is that existing U.S. affiliate having to file?
They would have had to file when they were acquired. So in this example, the foreign parent, say 10 years ago, acquired this existing, or let's say they acquired them in 2010.
Right.
They wouldn't have had a reporting requirement because it wasn't in the period where the report was effective. In 2015, the existing U.S. affiliate now acquires the acquired U.S. affiliate. That's when it triggers, is upon the acquisition or
Something new.
Something new, right? Yeah. So nothing that's occurred like pre-2014 would be subject to. Just because you hold a company there's a 10% voting interest held by a foreign company, that's not what actually creates the obligation to report. The reporting obligation is only created when you buy or you expand your business. Yeah. Okay, so Form BE 13B is used when a foreign person or entity establishes a new U.S. business enterprise. I forgot to mention on the 13A, all of this is subject to a $3 million threshold. So if the acquisition of a company is under $3 million, you don't have to file. Sorry. Similarly, on this form, there's a $3 million threshold. So if the establishment of the U.S. affiliate is under $3 million, then there's no obligation to report. But note that this isn't like just the cost to file the articles. This is, capital contributions. This is startup costs, like all of the projected costs to start the U.S. business enterprise. Okay, and so this would all be projected costs because you establish it day one, your 45-day period starts ticking, but you haven't necessarily expended all of your startup costs. Okay, and of course, then there's the 10% threshold requirement. So this would include the creation of new legal entities, even if they're just holding companies or they're basically there to funnel money down to the operating company or a similar situation. And it also includes, as we mentioned earlier, the acquisition of real estate for the purpose of conducting substantial construction and then selling or leasing. And let's see. So in the examples that I have, again, if you look at the foreign side, the upper part, which is the foreign side, you note that there's actually no foreign parent that holds more than 10% interest in the newly established U.S. affiliate. But because they're all part of the same affiliated foreign group, the entity in the U.S. which is newly established actually is subject to the reporting requirements because in the aggregate it's 10% or more. Okay. And then an example of indirect establishment would be when an existing U.S. affiliate basically creates a new US affiliate under it as a subsidiary, and the foreign parent still has a 10% voting interest in that company. And here it does because 50% of the foreign parent's 20% interest in the existing US affiliate leaves you with 10%. Any questions on that one? Thanks. Okay, the next form is actually for mergers. So it's sort of a subset of acquisitions, I guess you could say. But it applies when an existing US affiliate acquires another US business enterprise, and the existing US affiliate then merges into the US business, it merges the US business enterprise into its business. So the surviving entity is the affiliate. And again, the total transaction is $3 million or more. Okay. And so you actually would include in this, under this form, mergers which occur when a foreign parent acquires a US affiliate and then merges that US affiliate into another of its affiliates. So it doesn't actually have to be the US affiliate acquiring another entity and merging it in. It could be the foreign parent doing the acquisition. And then, so in the examples, I do again a direct and an indirect. The first one is a direct where the foreign parent directly owns the US affiliate and the merged business entity is merged into the US affiliate. But again, I note where there's you have to report on a consolidated basis because the merged entity has a subsidiary which it owns 51% or greater than 50%. So all of the financial reporting that's required in the report, you would do on a fully consolidated basis for that report. And then again, on the indirect, it's basically a subsidiary of the direct US affiliate which merges with a newly acquired business, and the ultimate voting interest held by the foreign parent is greater than 10% after multiplying it out. And then finally is an example where the foreign parent acquires the a US business entity and then merges it into an existing affiliate. The only thing that I caution you on that is that you have to really be careful of the timing. So if the foreign parent acquires the US business entity, that actually starts the clock for the acquisition reporting. So if they're not merging pretty much simultaneously, you might actually have to you might be subject to two reporting requirements. First, when you acquire, and then second, when you merge, because those are two separate transactions. But I think, well, I haven't done one of these, but my understanding is that you would, if you did the merger simultaneously with the acquisition, then you would just file the merger on the BE 13C rather than having to do two reports under A and C. Okay. Any questions on that? All right, moving on. So the next form is actually used when a US business entity, or it's a US affiliate, so it's already owned 10% or more by a foreign parent, expands its business to a new facility. So say for a law office, you would open an office in Hilo, but keep your Honolulu office. That would be subject to reporting on the 13D if that expansion was $3 million or more. However, you wouldn't include things like you have one floor of the TOPA building and you hire more attorneys, so you want to go onto the 20th floor as well. No, that's just an expansion of your existing facility. It actually, you have to have a new area that you're expanding into. It also doesn't, there's no reporting requirement where you shut down your facility because you're planning to move it somewhere else. So you don't want to practice in Honolulu anymore, you want to practice in Hilo and you move. So that's not subject to reporting. That's all I have on that one. Any questions? Okay, so the BE13E. So this form actually hasn't been released by the BEA yet because it's actually an update on prior reporting, and it applies to the BE13B form and the BE13D form. So when you expand your business and you report under 13D, generally you'll be doing ongoing construction, and in the form you would have to basically disclose what your projected construction costs would be on an annual basis. So you get 3-year construction period, what are you going to spend this year, what you're going to spend next year, and what you're going to spend in the last year. This form, the 13E, would basically be used to update and provide a more current actual costs of what you've spent in the past, and then an updated projection of what you expect to spend in the future. But as of June, the beginning of this month, they had not released the form yet. Anything on that? No?
So again, this is just if there's been a substantial change from what you were originally projected.
So on both the 13B and the 13D, they actually ask, is the property under construction? And then, so anytime you say it's currently under construction, you'll have to update with the E.
Gotcha.
Yeah. Okay, and the final form is the claim for exemption. And there's basically 2 different categories of exemptions. There's exemptions that you have to file for regardless of whether or not you're contacted by the BEA, and then there's exemptions that you only have to file if you are contacted by the BEA. So the first category, whether or not you're contacted by the BEA, you have to file an exemption if the total cost threshold is the only thing that you're missing. So if you meet all of the other requirements to file a BE 13A, B, C, or D, but you don't meet the $3 million threshold, then you would file this exemption. For example, if a foreign parent acquires a new business in the US, holds a 50% voting interest in that company, but they only had to pay $2.5 million for the assets and the company interest, then they would not have to file the BE 13A for acquisitions. They would just file the exemption, and that's all you have to do. The exemption form, it seems weird that you have to file something even though you don't qualify, but the exemption form is a lot easier to fill out, which is nice, and you don't have to disclose as much information. So I think it's a lot better if you can fit into one of these exemptions. And then again, number 2 is when you have a minority interest held by an entity subject to filing. So this would basically be in those situations where I showed you that you had to do consolidated filing. If they didn't have a 51 or greater than 50% interest, then you would, instead of filing a consolidated report, you would file an exemption. And then, so then the rest of the exemptions are actually, you don't have to file them unless for some reason the BEA contacts you and thinks that you're subject to the reporting requirements, why haven't you filed? And so you would file the exemption and say, well, we're not subject to filing and this is why. So the first one is when you're contacted, but there hasn't been a triggering event, and I think this was your question, Jennifer, is like, is it just from holding the company? It's no. There actually has to be some sort of acquisition, establishment of a new business, or expansion of an existing U.S. affiliates facilities. And then the second exemption under this category would be where the voting interest threshold is not met. So, the foreign entity only owns a 5% interest, or they actually only hold preferred stock with no voting interest, with no voting rights. So it's actually not a voting interest. So you would disclose that in the exemption, and you wouldn't be subject to the reporting requirements. And then, as mentioned earlier, real estate which is held for personal use, even if it's held by an LLC entity, you wouldn't have to report for that. You just file the exemption if and only if you're contacted by the BEA. And then the last one is if a foreign entity already holds a 10% interest in the company. I think this one is aimed at not making the company report twice, but at this point in time it doesn't really work, because most of the companies that are already held 10% by a foreign entity weren't subject to the requirement to report. So technically you don't have to report. So that's what I would follow, even though I don't know if that's necessarily what the purpose was behind that exemption. So those are the forms. As you go through them, like if you ever have to fill these out, I think having these cheat sheets would be very helpful, just to figure out what forms to use. If you ever have questions, the BEA is actually really good at getting back to you. I think especially because these forms are fairly confusing at times. And given the complex nature of some of the transactions that we deal with, it can get confusing exactly what to put or what to disclose. So they have an email that you can use or a telephone number, and with the email, they generally have gotten back to me within 24 hours. And I think they're in DC, so sometimes you get into work early and the answer's there. And that email, if you want to write it down, is be13@bea.gov. And this is specifically for the BE13 forms. They have actually like question lines for each of their different forms. So if you have a question on a different form, like a quarterly report, it's basically the same thing, just BE and then the number of the form at bea.gov. And the phone number, if you want to contact them, I found it a little difficult to get through just because of the time difference. But it's 202-606-5613, and generally they're really helpful. Oh, sometimes you might run up against the 45-day deadline, and we've found that they're fairly, they provide extensions very readily, especially if you contact them before the deadline. And again, you just use that email address or the telephone number and request the extension, and they usually get back to you really quickly. And also, if you need a copy of the reports, if you file electronically, it's a lot easier because it's available to you online immediately after you e-file. But if you send in a hard copy or you fax it in, you actually have to have your client send a copy or a written request on their letterhead and signed by an official officer of the company. So instead of doing that, what I would recommend is actually when you send in your report, including a receipt requested form, not just the one like on the mailing envelope, but you can have them acknowledge receipt and they'll send it back to you when they receive it and actually review the document to make sure it's complete.
When you say it's available, it's just available to you, it's not available to the public.
No, so these documents are actually confidential, and that's why it has to be, the written request has to be on the letterhead of the company and signed by an officer. All of these reports are confidential as required by regulation, I believe. And so they won't release any of the information except in the aggregated reports. So there wouldn't be any identifying ways to identify the information specifically to one company. Yeah.
And when you contact them with questions, you can just throw hypothetical questions, right?
Absolutely, that's what I did. I just, this is my case. Help me. Yeah, they're good. And actually, when I submitted the forms, I had multiple questions, and it seemed to have some continuity in the person responding, which is nice.
Yeah.
Let's see if I have any other closing tips. Oh, one of the other things is, each of the reports needs to be signed by an officer or general partner or an official basically an official representative of the entity who the report covers. So I would make sure that the client understands all of the information that's being reported, because they have to sign it and they make a certification that the information is true and correct, and so you don't want your client getting in trouble for not knowing what they're actually reporting. But other than that, if you have questions, you can ask them now, or I can hang around for a couple minutes afterwards if you don't want to ask it in front of the group. But that's it. That's the BE13.
Does anybody on the phone have questions for Kekoa?
They left.
Bye.